Hi everybody, this is Jason Lindamood with the Lindamood Law Firm, where we do estate planning and probate. And today I want to talk about trusts and what a trustee is, as well as who can be a trustee if we have a trust. But before we get to that, if you have any questions about estate planning or probate, you can always reach out to us by going to estateplaninfo.com. That is estateplaninfo.com. And from there, it'll take you to our website and you can set up a time for us to talk. So let's talk about trustees. And this comes in the form of if we have a trust, right? Not a will, but if we have a trust, what happens to our trust and who's going to be our trustee? Generally, the trustee is who our property is transferred to if something were to happen to us. If we are the grantor or the person that creates the trust. Grantor is another name for it. And the trustee has a duty to administer the trust under its terms, based on the trustee's powers and obligations that were listed in the instrument inside the trust itself. So technically, we can choose anyone to be our trustee. Or in most cases, they'd actually be our successor trustee, since if we create a trust, we are 99 times out of 100 going to be our own initial trustee. So we're really talking about who comes after us, our successor trustees, since we're going to be our own trustee when we're alive. Now, this allows us to be in total control of any changes that we want to make to our trust up to the point of death. So a trustee could be a single person, it could be multiple people, in which case they would be considered co-trustees. If we're talking about a typical avoid probate revocable living trust scenario, then we will generally be, again, our own initial trustee until something were to happen to us. And at that point, a successor trustee, in other words, the person next in line that we appoint after we're gone, would step into our shoes to make sure that the terms of the trust are abided by according to our wishes. And this could be one of our adult children. It could be a relative that we have extreme confidence in, or it could be a corporate trustee or even a bank, since they will, for a fee, take on the responsibility of acting as a trustee. And in most cases, if we have a corporate trustee, there is going to be a fee or a cost of them acting as our trustee to manage the assets of the trust. An important thing to remember is that whoever the trustee or successor trustee is, they all have a fiduciary duty. Let me repeat this. They all have a fiduciary duty to make sure that the terms of the trust that you created are executed in the way that the trust has provided for. In other words, the grantor, you, the person who makes the trust, the grantor, you spent some time and you spent some money creating this thing, this document that we call a trust. We put pen to paper, we've signed documents, we've had things notarized and witnessed. So we are, excuse the pun, trusting that the individual who is going to oversee the administration of our trust, once we're no longer here to do it ourselves, is going to do it both ethically as well as in a manner that comports with our wishes. And most trusts have some sort of a default provision, just in case none of the named trustees, the co-trustees, or the successor trustees are able to serve for one reason or another. And that safety net provision will usually, at that point, name a corporate or bank trust department to serve in that capacity. But that's a last resort, and if we can keep it within the family, so to speak, or keep it within our circle of loved ones or individuals that we have a relationship with and we truly trust, that's usually the better option for a typical family-based trust, where we're primarily just trying to avoid the probate process and the time, the effort, and the expense of going through probate. And we would have to go through the probate process, of course, if our estate plan was centered around a typical last will and testament. Because if we have a will, chances are that the will is going to have to be probated after we're gone. So figuring out who our successor trustees are, assuming we go the route of a probate process avoiding trust instead of drafting a will, figuring out who our successor trustees are going to be is a fairly important decision and something that we want to give some time and some thought to, because ultimately they're probably going to be the ones running the show when something happens to us. And they can skip that probate process altogether in many cases, assuming that the trust was fully funded and we've done the work on the front end in order to save our family from doing more work on the back end if we were to die. So on that note, that's all I have for you today. Once again, if you have any estate planning or probate issues that you'd like to discuss, head on over to estateplaninfo.com. That'll take you to our website where you can schedule a time for us to speak. Once again, I'm Jason Lindamood with the Lindamood Law Firm. Thank you for your time. Thank you for watching, and I'll talk to you again soon.